Hello, this is Matt on the Moon Lambo channel. Ripple and SEC refile new motion to resolve ongoing lawsuit. Folks, I gotta tell you, there was so much breaking news yesterday. I am still playing catch up with this stuff. Now, a benefit of that is since I haven't covered this yet, enough time has passed that I've been able to get perspective from a few of the most well-known attorneys within the XRP community sharing perspective here, and that will include attorney John Deaton, attorney Bill Morgan, and attorney Fred Rispoli. And look, this thing, it may or may not end here. So I'll tell you this. Two of the attorneys whose perspectives I'm going to share think it's likely that the judge is going to agree, okay, this thing's over. One attorney is actually less confident that that's going to happen after this most recent filing, if you can believe that. So there's a good chance it's going to end, but certainly not certain, unfortunately. You'll see what I mean as we go through this here. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so you may recall that the last filing that the SEC and Ripple jointly filed was rejected by Judge Torres. They were hoping that this thing would just come to an end. Judge Torres, a lot of people think she was actually kind of pissed off because she spent like half a decade dealing with this litigation. And they're like, just kidding, let's just end this now. And then the SEC and Ripple come together. And of course, that's because of the administration changed the way the election went. But still, I can imagine Judge Torres maybe feeling a bit frustrated about that. And so she said no. She said, nope, absolutely not. You didn't procedurally, you need to file this a different way. That's one of the things that she said. And then she was basically, it was expected that there would be more vigorous arguments as to why something like changed to such a degree that she should reconsider her actual decision. And she wasn't happy with that. So there was broad expectation that there would be a whole lot of that happening in whenever the new filing would occur. And having read this thing, no, that didn't really happen. And so that's why there's additional concern, as you'll see as we go through this. So here's the headline from Cointelegraph. SEC Ripple file motion to release $125 million in escrow as case winds down. Ripple and the United States Securities and Exchange Commission filed a joint motion on Thursday to release the $125 million in funds held in an escrow account to pay for settlement costs ordered by the court. According to the letter submitted by both parties, $50 million will be transferred to the SEC for the civil penalty against Ripple, with the remaining $75 million transferred back to Ripple pending court approval. The filing attorneys wrote, and this is a quote, "The parties' proposed resolution will preserve the resources of the Second Circuit by avoiding the need to decide appeals, obviate any remand for further proceedings in this court, and bring 4.5 years of hard-fought litigation to an end," end quote. The SEC lawsuit against Ripple is a landmark case for crypto regulations in the United States, and formally ending the litigation will be a symbolic victory for an industry that has already largely won its battle for legal legitimacy in the US. Okay, so that's certainly true. And then there's the whole issue of the injunction, because there is an injunction standing against Ripple right now, and as a result of that, it's changing the way that Ripple does business. And it is stupid, and it should go away. We'll see if that happens. But as a result, Ripple's not using XRP as a bridge currency for any corridor that touches the United States. And so we found out, I can't actually remember, everything blurs together. It was like a year ago, year and a half ago. At some point, we found out from Ripple that after the injunction, they'd actually ended up using Tether, the stable coin, for any corridor touching the United States. But they are still using XRP for any corridor not touching the United States, and there's no reason that would change. So Ripple can still conduct business, but this is far from ideal. And I personally don't think it's fair or right. That's just my humble opinion. But that's the other piece of this that Ripple wants to have pulled back. That's another big reason that this really matters. Shout out and credit to attorney James K. Fallon of the XRP community for sharing this document here. And here's what attorney Fred Rispoli of the XRP community had to say about this, and he ain't happy. He's a bit concerned about the way this went down and a bit disappointed. So he wrote, "In the newest saga of SEC v. Ripple, I don't like this filing based on how obvious it was from Judge Torres' last ruling that she was pissed. I recommended a long, detailed motion explaining the SEC's failures in crypto regulation with commissioner declarations and some apologies from Ripple for what it got tagged on. Instead, we got one paragraph on the other SEC dismissals and a paltry mention of the SEC Crypto Task Force. Oof. The parties cite enough law for the court to grant it, but they also did the same in the last one that was denied. This is pure discretion on Judge Torres whether to grant, and I don't think this gets it done, sadly. In my opinion, one of the rare whiffs we've seen in the legal acumen of Ripple's counsel. I'll be hopefully optimistic that Judge Torres reads the room and is willing to, just get this case off her plate, but my confidence is low. That said, leaving the injunction as place is not a death knell. Ripple can still sell XRP to institutions, just not in the same way it did pre-2018. Conservative institutions will be hesitant to get involved. More forward-thinking ones will not. Yeah, and I would hope that even if the injunction stays in place, and again, really hope it doesn't, that they should recognize, okay, Ripple's still following the rules as they exist right now, even though that's a handicap that Ripple's competitors don't have to deal with. And what they're doing moving forward, and you guys are probably aware of this by now, but instead of using Tether, of course, Ripple did launch their own stablecoin, RLUSD, and they're actually, they did announce some time ago, officially, so we know this for sure, which is, it is an easy prediction to nail, but they're going to use their stablecoin RLUSD instead of Tether as a bridge currency for any corridor touch in the United States. Now, that actually is still good for XRP because all of the RLUSD transactions that occur on the XRP ledger require XRP. So this is still a net plus for XRP. We just prefer it if XRP were the bridge currency for this corridor, but there are workarounds. It's not literally the end of the world, but it does kind of suck donkey balls just a bit because it's not fair. It doesn't make logical sense, and here we are. And then you have Circle jumping in, obviously. They announced that they're starting their own FX business here, and they're not crippled like this. They're not handicapped. So obviously not fair, but anyway, is what it is. There's XRP community member Sherry, and I'm not sure if she's an attorney, the way that she talks and with how informed she is. Maybe she is. I'd not be surprised. I don't know if she's publicly stated that, and it's not in her bio. If not, she must have been closely related to the legal industry for some reason, because she's always been incredibly well-informed, insightful, reads these documents, and understands in a way that only an actual attorney can understand, rather than someone like me who just plays an attorney on YouTube, pretending. Anyway, so she says, I'm with you on this one, Fred. I genuinely had been surprised by her response to the initial request. While I feel there is a slightly higher chance she'll come back with something more positive, I am more concerned than I was before. Fair enough response. Anders responded to this XRP community member. He said, what would be the next move if Torres rejected the settlement? Can Ripple just drop it with the injunction in place? And Sherry said, if her response is much the same as it was before, then nothing changes. Ripple must then decide if they wish to continue with their cross appeal or not. In the meantime, the injunction remains in place. So that would be the worst aspect of this for Ripple, frankly. As far as the money, that sucks too for them. But as I highlighted in a video, I think yesterday, Ripple announced that they have $3.7 billion in cash. That's on top of their XRP reserves. I'm talking about just straight up cash, $3.7 billion. So the gun's to be fine. Okay, Ripple's not going to be hurting for the money, but still, I don't think that this is the right. Especially, there were no victims in this even. That's why this penalty. Just to be clear, and I've mentioned this before, but the penalty doesn't go to any of Ripple's customers because none of them were harmed. It goes to the U.S. Treasury. Did you know that? There was no harm. So normally in a situation where a company's found to have done something wrong like this and there's a penalty that's paid, it normally would go to the victims. There literally are no victims, which is hilarious and stupid. They've all the years wasted, all this money spent, and for what? It's just ridiculous. And Attorney Rispoli mentioned, P.S., we should hear from Judge Torres within 2 weeks, so we'll get a response sooner than later. Attorney Bill Morgan of the XRP community responded, and he said, I agree that it is not a very strong argument, but I think Judge Torres may grant the motion. She may actually be more fatigued with this litigation than the XRP community. That's possible. She's the one that's doing the heavy lifting and actually getting stuff done here. But I think we're all sick of this too. And the good news is, again, XRP has legal clarity regardless. So for us in the end, it doesn't matter. I'm still covering this though because it's fascinating. I want to see this journey through to the very, very end. And I'm just as curious as you guys as a result of this. And let's be real, also in a bull market, even though this doesn't actually matter for XRP, the market could respond anyway. That stuff like that's happened before. Here's another one from Attorney Morgan. He says, just reading today's Ripple and SEC joint motion to Judge Torres over lunch, it does not become stronger and more impressive the more you read it. I just have a feeling she's going to grant the motion anyway. Okay, so he's optimistic, even though he doesn't actually think that it's exactly their best piece of work, which is consistent with what I keep seeing from any legal mind that talks about this. Here's another post from Attorney Morgan. He says, in the joint motion filed today by the SEC and Ripple to show exceptional circumstances, the parties rely on authorities that have held that exceptional circumstances exist where modification of a judgment is necessary to facilitate settlement that would obviate pending appeals and where relief from the judgment is a necessary condition of settlement. If the modification of the judgment to reduce the fine and dissolve the permanent injunction is a necessary condition of the settlement agreement, which it is, the corollary of Judge Torres not accepting this argument and allowing the motion is that a necessary condition of the settlement has not been satisfied, and the settlement agreement will be unable to be performed and at an end. If the motion is not allowed, and the settlement agreement is not varied or a new settlement agreement entered, then there is no settlement, and the appeal and cross-appeal would continue. Yet for months, influencers have been saying that it is over, in the case, is closed. This is not so. The fate of the current joint motion is very important. Okay, and so this is a very real hurdle. Attorney Morgan, of course, is correct about that. I'm still optimistic. I'm keeping my viewpoint even after this. I still think this thing's going to go away. We'll just see how it looks. And fine, if they actually have to proceed with this thing and there's an actual cross appeal, okay, fine. But it'll still go away after that. But I'm still optimistic. Maybe a little more cautiously optimistic after this, that it is still going to go down that way. And so we'll see. Here's a post from Attorney John Deaton. He says, is there a chance Judge Torres says no to the SEC and Ripple? Based on the weakest brief filed in the case to date, the SEC and Ripple are betting that she will not seriously consider denying it. I expected a more detailed brief describing the exceptional circumstances necessary to get her approval, but the parties determined it was unnecessary. I'll break it down tomorrow. And so there's another attorney agreeing, wow, this is not exactly the best work from Ripple. And it's Ripple and the SEC here. It's not within the realm of what Attorney Deaton was thinking would happen or what he was hoping for. And that's disappointing. That's what I keep seeing from any attorney that's opined on this. It's not exactly ideal. And so he's going to be on YouTube tomorrow covering this, and I'm absolutely going to check that out. I'm looking forward to see more of what he has to say. I may not be able to catch it when it's live, but I'm absolutely going to check it out. I'm very curious to what he has to say. A former SEC attorney, Mark Fagel, responded to Attorney Deaton here, and he said, maybe there just aren't any exceptional circumstances they could provide with a straight face. It ultimately comes down to there was an election and now the SEC doesn't care about crypto. Is that legally sufficient? Doesn't seem like it. Okay, and so it is true that the reason that we're even having this conversation is because of the way the election went down. Like, I'll give them that. I've been saying that from the beginning. But it doesn't mean that there aren't good arguments, so I would disagree with him there. You don't have to be an attorney to figure that out. Because think about it. Think about all of the terrible things that happened throughout the Ripple case and all the disgusting things the SEC did. The SEC could have fallen on the sword, as I think it was Attorney Rispoli that said that, and just said, yeah, we done messed up. So there are arguments that could have been made. And so if Attorney Fagel's perspective is, well, they didn't put forth these arguments because they don't exist, I say, no. They didn't want to. Maybe they just didn't want to. There's more stuff that could have been argued. Let's be real. We can get creative with that, obviously. And then Attorney Deaton also had to say this, and this is more detailed. Check this out. Someone posted a comment that said, we get it. You and Attorney Rispoli believe Ripple and the SEC should have kissed Judge Torres' ass more. That's not it. In fact, I believe there's a 70% chance she grants the relief requested, and I'll discuss it more in detail tomorrow. What I was expecting wasn't ass kissing. And no, I'm not being super critical of the lawyers who filed it. They're much more experienced than I am in these matters, And experience is the greatest teacher in life. In fact, the lawyer who signed on behalf of Ripple is a former SEC director of enforcement. I was expecting some falling on the sword by the SEC that, I guess it was Attorney Deaton that said that, not Attorney Rispoli. I was expecting some falling on the sword by the SEC that prior leadership was overly aggressive related to crypto, citing how an appellate court found it arbitrary and capricious, or how SEC lawyers were sanctioned in debt box because of this over aggressive conduct against crypto. Hell, in the Ripple case, Judge Nepern, who was assisting Judge Torres, stated SEC lawyers, quote, lacked faithful allegiance to the law, end quote. And so, folks, this is why I was saying a couple minutes ago. There absolutely are arguments that could have been made, and Attorney Deaton's citing multiple ones right here. They just didn't do it, unfortunately. So if they had, and maybe the SEC didn't want to sign something, where that's crapping all over them even more, even with the change in administration, maybe that is it. Maybe that is it. I don't know. But maybe that's why we got the document that we got. But they did file it together, at least. So they're in agreement. It's just, those would have been the best types of arguments to make, and they are persuasive, I certainly think. It's just a shame that those arguments weren't made. That's all I'm saying here. But the idea, like Attorney Fagel said, that there just aren't any arguments. No, of course there are. Get creative. You don't even have to get that creative. It's not that hard. Attorney Deaton's citing them right here, and he's correct. Anyway, John continues. He says, I thought there would be a reference to pending legislation related to crypto, Genius Act, Clarity Act, and that is indeed an exceptional circumstance, along with facilitating settlements, saving judicial resources, etc. I also thought Ripple would highlight how unfair it would be for all this regulatory clarity that's coming, yet an injunction hanging over its head would place Ripple at a disadvantage against competitors, i.e. Circle. And folks, that's what I was referencing earlier. And John is the reason that I even thought about that in the first place, how there is that disadvantage. He's right. And then he says, banks and other companies prefer to do business with a company that doesn't have an injunction against it. I'm sure some former SEC lawyers are reading this and thinking that the mere fact that I believe this kind of stuff would be proved my lack of experience in these types of cases. Maybe. I expected more of an explanation that meets the high standard to get a judge to rescind her ruling that she firmly believes, whether right or wrong, is consistent with existing law, instead of assuming she'll grant it because you cite a couple cases for her to hang her hat on to grant it, if she so chooses. In sum, the argument filed by the parties could be summed up this way. Look, Judge, elections have consequences, and this is one of them. Tune in tomorrow, and I'll objectively give you the reasons she should grant it and the reasons she shouldn't, and then Crypto Law will do a poll on the outcome. Yeah, so there's the insight from John Deaton and a couple other well-known attorneys within the XRP community, and I appreciate the perspective. So yeah, I guess I don't know about you guys. I'm a little more concerned about this than I was before this filing. I was under the assumption, I'm not an attorney, so maybe naively, but I was certainly expecting that there would have been something more to it. This document is strikingly similar to the last document. That's the thing. So we'll see what happens. I guess I'm still more optimistic than not, but we'll see here, folks. You guys tell me what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.